the person whose channel it is, who owns the channel, believes that everything that's on the channel belongs to them. But at least in US copyright law, the person who technically owns the videos is the person who is the videographer.
How the hell did you end up being a lawyer for creators?
So I'll take it all the way back to when I was growing up. I love music. I am obsessed with Freddie Mercury and the band Queen. And I was in garage bands. I was the lead singer. And at the time, I was like, I'm going to be a rock star. And my parents, being immigrants, were like, no, there's no way. Go get a real job. Go get a real degree. And later, if you're in your early 20s and you're sure you want to do this, then fine. So I got a degree in economics. And then I got a job in finance. And at the time, I was like, maybe I'll go to like a conservatory, or I'll go do something after I get my degree. And my sister started putting out content and putting out music. And she was one of the early like musically verified creators. And she was also streaming on something called YouNow at the time. And she was one of their like first partnered creators. She was 15 or 16. And I was her manager. So I would negotiate all of her deals for her. She got, it's like a joke amongst ourselves and amongst the people who know us. She got asked to do the red carpet at the American Music Awards. And she was there with Coca-Cola, just kind of like, walking up to people and live streaming. And I negotiated that deal for her before, I think I might've been a first year in law school, or maybe it was right before I went to law school. I can't remember which one. And I was like, I really like this. I really like doing this. And I like being the big sister in like this different way. And so I started really going at it with law school about wanting to work in the entertainment space, because that's what I knew. It's what I cared about. It's what everyone I cared about was doing. And it was a way, being a lawyer in this space is my way of taking that big sister kind of like role and applying it to a bunch of people who really do need it and can benefit from somebody who's going to go through and read with the kind of care that I do and make sure that you're not getting taken advantage of. And so I went to Harvard Law School. I worked really, really hard the entire time I was there to only take things that were going to be useful to this space. And I networked my butt off. And then I got out to LA and started running with a career through a big law firm, one of those like fancy ones. I was in their entertainment office. I was at a music company for 5 years, working as one of the 5 lawyers that kind of did a bunch of the stuff. And if you know the music industry, it's a very legal heavy industry. So lawyers in those kinds of companies are doing a lot of things. And then I went to Meta. And finally, I was like, you know what? Like, I really want to just do this myself and feel like I'm helping people on a one-to-one basis. And I started getting a lot of people coming to me and asking me for help. My sister, while I was at the music company, was running a TikTok shop partner agency. I was her company's general counsel. So I met a bunch of people that way too. And this just, it's an interesting field. Intellectual property in the music and creator space is incredibly complex. So my inner nerd is satisfied. And it's like just a new frontier of technology and entertainment and intellectual property and a bunch of really cool people putting out really cool things. And I could not have asked for a better place to end up. And so that's how I got here.
Super cool. So you've seen it from all different angles, right? Like you've seen it from like big international music, inside at Meta, working obviously early stage with your sister, and now creators, and you've actually got more formal training. Mm-hmm. What experience has taught you that creators generally being treated badly, right, and taken advantage of? Like, is there something that sort of shows you that what that looks like in practice generally?
Yeah. So, like, as you said, I've been on this in a bunch of different capacities, and just to set the table a little bit, I think sometimes people villainize the folks in-house at these companies, and, because the reality is creators do get taken advantage of. But when you're looking at this negotiation of any kind of deal that happens between a creator and a company, it's not like a bunch of people like Dr. Evil and Austin Powers, like trying to figure out how they can like screw somebody over. Like, that's not what's going on. It's just a bunch of people trying to do their job. And so it's not as emotionally charged as I feel like creators sometimes think that it is on the other end.
Well, the way creators will see it is the blood-sucking lawyers who are trying to steal their IP.
Yeah, I mean, and to some extent it feels that way because ultimately it's people trying to exploit their IP. It's not necessarily stealing, but it is definitely exploiting, and sometimes exploiting for not a fair shake and not a fair deal. One way that I have advised many creators, especially early stage ones, is when they get these deals, especially at the beginning, right? They're so excited. Like, they're like, I made it. This is great. And they see it as like a gift instead of a business opportunity. And the brand's not doing you any favors by working with you. Like, you're only getting this opportunity because your work's valuable. And they're only working with you because their marketing team wants to use your face or your content or whatever to get their product out there. And so understanding that at a fundamental level as a creator, especially at the beginning, is so important, because then you can advocate for yourself effectively and not think, oh my God, this is going to be such a big problem if I say anything. Because like, so many of these creators don't negotiate their deals at all. And if they do, they negotiate it just a little bit on like, maybe, oh, I need a little bit more on the money. They're not reading it carefully. They're not asking for basic things. And it's a lot of the time, from when I've spoken to them, it's because they're afraid that if they ask for anything, they're going to get the door slammed in their face. And that's just simply not the truth. Maybe you'll get a no, but you're not going to get it, I don't want to work with you anymore, because you asked for something. As long as you're not asking for like the whole world and more, like, people are understanding. So, I mean, as a former in-house, like, so many times I've been on the inside of the deal, and I've wanted to take the creator and shake them and be like, we could have given you so much if you had just asked for it nicely. And they don't. And I can't say anything because my employer is my client at the time. And it has hurt me so many times over and over again in my soul to just let those deals go through, because I'm like, man, you could have gotten so much more and you're leaving so much on the table.
Based on that, then, can we ask, what are those big mistakes they tend to make in the contract phase?
First of all, not looking carefully at the rights grant is my number one, and 2 and 3 and 4 and 5 that I tell everybody is like, you got to read that so carefully, because you are an IP business and your entire asset class is probably going to be IP unless you start moving into a physical product space. And you need to know what you're giving somebody. And it's like going to a market and saying, I want $5 for this apple, but the apple actually also is like 3 oranges too, because they snuck those into the cart and you didn't look. So it's really important to read that carefully. It's important to understand, revisions. If you're doing a brand deal, for example, or if it's a syndication kind of deal or a streaming kind of deal, can they sub-license it? Like, because then they're making money off of what they're giving to somebody else. Like, they're then standing in your place and sub-licensing it to someone else, making money off of that. Are you going to see that money? And can you approve it or not approve it? Those are like just scratching the surface of things that I've seen people not ask for, not ask questions about. And then they find out later that something happened and they're like, oh my God, Rebecca, help me. And I'm like, well, but you signed this. I'm going to have to try to renegotiate it, but your leverage kind of goes away once you've signed.
Yeah. You mentioned that creators are effectively in an IP business. Mm-hmm. Do you think they see themselves in that way?
No. I want so badly to, like, I've been ringing this bell for like probably the last 2 or more years that if you are a creator, you own an IP business. But I think a lot of people don't think about it. They think of IP as like a trademark or a patent, and they're not thinking about it as, if you're making an episodic like YouTube series, even if it's just one episode, if you're posting one thing on Instagram, like one photo, that's IP. You created something copyrightable, and they're not thinking about it that way. And it causes so many problems later down the line when they start actually taking it more seriously as a business. And then they realize they're an IP business and they're like, oh no, what have I done?
Is there a point they look at, go, uh-oh, I have an IP business. What have I done? Is there that light bulb goes off at some point?
Yeah, when they see that they could have made a lot of money and they can't because they gave it away too early, or they get an offer from an investor or from a distributor for their content, and they find out then, oh shoot, I don't know who owns the content. Like, is it me? Is it the camera guy? Is it my collaborator who like worked with me on some stuff? Like, who do I owe money to? And like, who owes me money? I've seen that happen a lot of times where that's the moment where the light bulb goes off, and it becomes such a nightmare, and it's so much energy and time and expense that goes into fixing it as much as you can, and kind of reconstructing from day one what everyone owns, what everyone is owed, and what can you actually salvage from your content library, basically, to license out, to sell, to exploit yourself.
Okay, but what's an example, or what's like something, IP ownership mistake that you've seen a creator they've made early on, but right down the track, it's kind of like come to bite them in the bum, and it's really hard to unwind?
So let's talk about there's somebody that I've talked to about this before, where they have they like co-create let's call it, it's a YouTube show. They co-create a YouTube show with somebody, and one person is on the camera and it's their channel, and the other person videotapes everything for them. They don't have an agreement between the two of them, and the person whose channel it is, who owns the channel, believes that everything that's on the channel belongs to them. But at least in US copyright law, the person who technically owns the videos is the person who is the videographer. And unless they have an agreement between the two of them that says, I am assigning to you, the person whose channel it is, my right, or licensing my copyright in it, then you have a problem. Unless, like, if you have no paperwork, you have a big problem. I see that happen a lot of the time. I see with music specifically, but I've heard of similar things happening in the creator economy more and more. Texts that that are an agreement between two people, that then I get oh my God, like, we agreed on, there's a percentage of rights that I said, but I meant a royalty stream. I didn't mean ownership. That happens sometimes. Or, I agreed with them that they are going to be a collaborator on this particular episode, but I don't really want them to have a part of it. I want them to have some percentage of whatever the YouTube money that I get is. But like, if later down the line I want to sell this as part of my catalog to like a distributor, or I want to license it to a distributor, like, I don't really like how to clear that becomes a big problem later. You need clear chain of title.
So what I'm picking up, what you're putting down, is that a lot of creators, either because they don't know at the time, or from my experience, because they feel icky about it, about getting like down to brass tacks and being clear with like a collaborator and being like, hey, like, we might not have anything of value yet, but there is value, but it's not, there's no dollars assigned to it. But hey, let's be clear on how this lands now. And one example that reminded me when you were talking about that first one, where there's a creator, essentially co-creators potentially, one on camera and one holding the camera, is scares the daylights out of me. But I hear of a bunch of creators who don't have employment agreements or contracts, and they have videographers filming all of their content, and they have no agreement at all. And let me check with the legal eagle sitting across from me now. If that's the case, then the person shooting the content owns it.
Yeah, I mean, it doesn't have to be an employment agreement, but you need some kind of IP assignment. If you don't have that, the default is to assume that the person who owns the content is the videographer. It depends on what you're doing. There are certain classes under US copyright law that need to be an employment relationship, and there are some where you can specially commission something, and there's a lot of different rules and parameters over what counts as what's specially commissioned. But yeah, I mean, at a very minimum, you need an assignment agreement that says, if it's not a work for hire, right, which would be ideal, that they're assigning to you all of their rights in the work, which would be basically them selling to you or giving to you all of the copyright ownership. Or if they're not willing to do that and you're okay with it, a perpetual license that is only for you, an exclusive perpetual license throughout the universe and in all mediums hereafter devised, that only you can use that particular video. and you get to decide who gets to use it. So you get to sub-license it. These are all the things that when I talk to a creator about the brand getting to do it, I'm like, don't do that. But like, if you have a videographer or someone who's an independent contractor who's working with you, it does actually make sense. And that's the only way that you as the creator and the creator business can go ahead and use that and monetize that content later.
You've talked obviously about that IP being so critical and the IP being the business itself. And you've just pointed out some big pitfalls that you could very easily stumble into. It sounds like that has to be thought of from as early as possible. I think a lot of creators think, oh, I'm just small. It doesn't matter. I'll bootstrap it and do everything, really on the cheap. And then I will worry about that later down the road. And doesn't sound like that's the case.
No. Day one. If you're putting out content, you're knee deep in IP, end of story. Like if you're creating it, you've got collaborators, you have to work out who owns what, like we were talking about, and who's owed what. You might be using IP that belongs to other people, whether you're putting in music or you're using pre-existing creative works, and that can come back to bite you in the butt if you're not super, super careful about everything you're doing. And like, look, I know it's super daunting as an early stage creator who's not making a lot of money, but the reality is, if you wait until the video goes viral to work all of this out, then you're going to have a really big problem on your hands. And it's going to take a lot of money and time that you won't have at that point, because you'll be busy dealing with this ballooning business that you've got to figure out ownership. And you're opening yourself up to a lot of legal liability. And, when things go viral, when you made it, you start getting sued. So being careful and making sure you're not going to get sued because you don't have sloppy ownership paths, sloppy paperwork. And it's easier then later that you can actually sell your business should you want to do that, sell the individual content or license it out should you want to do that. It's just good sense. And it's something that people don't think about in an IP business because what we're doing is intangible. But like any other business is doing all of these things from the beginning. So we shouldn't be any different.
Do creators get sued a lot?
Yeah. For creator, it depends on how big you are, right? Like any creative medium, any creative anything, you get sued a lot. So much so that, just speaking from the lawyer's perspective, like it's so hard for all of us to get malpractice insurance because of how frequently people get sued. It's really hard for creators to get insurance for errors and omissions because of how frequently they get sued, at least in the US, where we're very litigious, right? Copyright law is very creator friendly for the most part. And it depends on what you're doing, but if you use Disney's stuff, for example, like be prepared to get sued. If you like put Mickey Mouse in or at least get a cease and desist and then have to take everything down. And honestly, more than getting sued when it comes to posting things online that might be infringing, in the United States, there's something called the Digital Millennium Copyright Act. And it's what allows people to put up YouTube strikes and all of that so that YouTube and the other platforms don't get sued. And this is something that they came up with in the 2010s to make it so that these big platforms with deep pockets don't get sued. You have to go after the individual. And the way that they've devised this is all of the copyright strikes and people getting their accounts taken down. And honestly, I would argue that getting your account deleted if you're a big enough creator is worse than getting sued, because that's a huge part of your income stream, a huge part of your livelihood. And that's way easier to happen to you if you're infringing on someone's copyright than if you don't, than if you just take care of it and get it done. It's a lot faster that you're going to come crashing down than someone just suing you. And people will do that because it's easier.
Very interesting.
Yeah.
With the fear of the big behemoth of Disney and their IP lawyers and copyright strikes. And yeah, I think it's a really good point though, that you don't have to be sued for the impact to be exceptional. And even just pointing out that it's very common, right? So the protection, like I think it's quite common for folks to think it won't happen to me. So it's like she'll be right, and as an Aussie would say. So super interested in what we can learn from the music industry, because they have been protecting their IP and commercializing it very well for a long time, and it's complicated. But what can we learn for the creator ecosystem, the creator economy from music?
So in my view, the creator economy is kind of going through the early stages of the music industry, like the 50s and the 60s, when the music industry was really starting to like hit a point where people were getting big and internationally known. And there was this handshake deal culture in the 50s and the 60s. Nothing really got written down. And there's a lot of like, we're friends and trust me, bro. And not that they were saying it that way, but you know what I mean? And like, I think of this one example for handshake deals where John Lennon and Paul McCartney have this agreement that was just an oral agreement between the two of them that anything that either of them writes, irrespective of whether it's together or solo, has to say Lennon and McCartney in that order. And in like the 2000s, Paul McCartney decides that he's going to swap that order. And Yoko Ono decides that she's not happy with that and that he is breaching an agreement that they had. And she threatens to sue him. She didn't, to my knowledge, at any point like initiate proceedings, but it made headlines for like a long time after that. And he ended up putting it back because he didn't want to deal with it anymore. So this is something that's happening right now. A lot of handshake deals, a lot of trust me bros, a lot of, we don't know what the paperwork needs to look like, so we're not going to do it. We're not big enough to worry about this. It's a lot of the same early stage stuff. The other part of this is like even into the 60s a little bit is that like predatory development deals kind of era of the recording industry where people like Prince had really bad deals. And then, you think about, you think of Prince, you think of the artist formerly known as Prince. He went through this whole era where it took him like 20 years to get his masters back. And this is something that musicians have kind of already paid for, is like learning this lesson over a long period of time. The disadvantage in some ways that the creator economy has is that virality takes such a short period of time, and this industry is moving so fast. We don't have the luxury of the music industry of it taking like 50 years to get to a point where we get to protect our things. We've got to quickly look at what they've done, see how everybody got it wrong, and correct course really fast so that this doesn't happen to creators, and get those contracts sharp the way that the industry contracts are in the music industry. Get lawyers earlier because that's what musicians are doing, and understand you don't have time to like wait to do all of these things until after you're famous. Like if you wait, you end up getting into these bad situations like the Prince situation, like the John Lennon situation. And it's very easy to slip, and paperwork needs to happen while things are going, and not after.
Is there maybe like 3 tips you could give creators who are probably wondering, well, where do I start in the space, to say like, these are the things you need to focus on at a bare minimum to at least protect yourself from day dot?
First of all, LLC or a corporation needs to be one of the first things you do. I heard from someone today about someone that they know who was told by a CPA, you don't need an LLC right now, because for taxes, you don't need an LLC right now. It's not really going to help you with your taxes, which like, sure, later on, when you make enough money, an LLC or a corporation can be a really great tax benefit to a lot of people. And so the advice was, it's not going to help you right now. And I was just like, it's not about the taxes. It's about the risk and the liability. Like if you don't have an LLC or a corporation, you don't have that corporate veil that shields your personal assets. If you're signing everything as an individual and someone decides to sue you because they slipped and fell on a shoot for one of your posts, one of your videos, they can go after your house, your car, your individual assets. They can't do that if you have an LLC and you're managing it properly. That's number one. The second is you don't need a lawyer for this, but like at a minimum, just having a piece of paper and sitting down with whoever's working with you and being like, all right, let's talk about all of the things that we need from each other and what we're willing to do and who owns it. And like, I would prefer that you had it written properly by someone who knows the law. But if you can't, sit down and just be annoying and detailed and be like, look, like, I just don't want us to fight later. Like, let's sit down and make sure we have everything written out. That would at least give you a paper trail of what your intentions were at the time. And it's better than a 3-sentence text that says, hey, bro, I want you to come over and film this thing. It's better. It's not perfect, but it's better. And then lastly, honestly, trademarking your brand and making sure you have that set is really important. It's expensive. I'm not going to lie. It's going to take a few $1,000s to really get that together. But getting it early is important so that someone else doesn't come in after you. I mean, if you think about like Jules LeBron, who got really famous for the very mindful, very demure, someone trademarked their very mindful, very demure out from under them. And it took them a lot of legal fees and work to prove to the trademark office that it actually belonged to them and they were using it in commerce first in order to get that other trademark that had been filed booted off of the trademark system. So you don't want to be that person. Don't let that happen to you.
Wow. Good tips.
Love it. Yeah. Yeah. Okay. Great. Get an LLC, write down who owns what,
Everything.
who's doing what, and then trademark.
Yeah.
Yeah.
Is there one mistake that people make that it's just super hard to unwind? I mean, obviously there are tons of them, but have you seen one that's particularly tricky?
Yeah, I mean, it's very much the not writing things down. Copyright assumes that if you have a bunch of people collaborating on something, if there's no written anything, that everyone owns an equal part of it. So if someone's just kind of doing a couple things, small things here and there, you need to make sure that it's clear who has more ownership of something, who has less ownership of something if you're collaborating with somebody, or if someone doesn't have ownership at all, that's also very important. So that's like the biggest thing I've seen it over and over again where people freak out after the fact and they're like, no, like I didn't want to give this like, you know, person who was in the room, in the songwriter's room for musicians, you know, a third of the songwriting on like of the composition on this song. But because they were there and they gave me like 3 words and it got written in there, and we didn't put a split sheet together, then they technically own a third and they have to like go and like beg them, which at this point they have no leverage, and who's going to give up more than they were supposed to have, to do things and like make it right. I've seen that with books. I've seen that with a lot of things where people don't understand that they need to be very clear about who contributed what. And so that's a huge thing that's very difficult to unwind after the fact, because it like there's a lot of nuances in the copyright law about when you have the assignment done and what counts, and making sure that that's clear. Even if it, and again, this is a very easy thing to do. Everyone writes down on a piece of paper, I own this much, you own this much, you own this much, and then everyone signs it. And at a very minimum, it's very clear who owns how much, and it's not a 3-way split if there's 3 people, for example.
Let's shift gears a little bit, because we've been covering sort of like creators protecting themselves through like their agreements and setting up their company structures, etc. Right? But a lot of creators will they won't be the originators of deals, right? Like they won't be the ones coming up with the contracts and the like with the offer, etc. Sure. Whether that's licensing or a brand deal or a whole bunch of other opportunities that come their way. But what's a single clause that you see all the time that creators sign away without realizing what they're actually committing to?
So I
That's
feel
a scared laugh, isn't it? It's like,
yeah.
Oh God.
Well, one of them is they don't understand the breadth of the usage, like we talked about, right? So one thing I've been seeing a lot of lately is sneaky language in lots of deals. This is platform deals, this is brand deals, this is everything. That's this really broad license to use your content, your name, your image, your likeness, your voice, your mannerisms, whatever, where if you read it carefully and conveniently in the brand's favor, it gives them the right to train their AIs on it and maybe eventually do something where they can remake you for their own purposes without needing you anymore if their technology gets there. And look, I understand that we're moving very quickly from a technological perspective, and this can be helpful for editing purposes or other things. So sometimes it's fine, but a lot of it can be really broad. And
what would that sort of look like, Rebecca? Like just broadly without
Oh, I have TikToks right here. Hold on.
Okay.
I have TikToks.
Amazing.
And to be fair, if you're using TikTok, you've already agreed to this.
Right.
But it's good to know for the future. And it's important to try to keep it from becoming super standard. And a lot of people don't read it and it gets hidden places and they don't look for it. And I'll tell you why I'm freaked out about it in a minute. But so here's what TikTok's terms of service says. I literally pulled this earlier today. Are licensed to use your content includes our rights to access, reproduce, distribute, share, download, adapt, or make derivative works, e.g. to translate or create captions. But e.g. is not a limiting list, it's an illustrative list. So perform and communicate your content to the public, e.g. to display it, for the purposes of operating, improving, and providing the platform and developing new technologies, and then in parentheses, including training, testing, and improving our machine learning models and algorithms, and services for TikTok, USDS joint venture, and our service providers, blah, 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 right? Where it says, for the purposes of operating, improving, and providing the platform and developing new technologies and services, is very broad. And you're basically saying, use what I give you and do whatever you want with it. And what freaks me out about this, just, from seeing what happened a long time ago with data and the sale and usage of consumer data, is if this becomes industry standard and every brand has this in their deal, and I've seen record labels include similar language in their deals, what we're doing is we're making it okay in theory, not in practice yet, because there's not really a great way of doing it yet, for someone to take content that you made and then make new content with it, because the derivative works is in there and improving and using machine learning is in there. So in theory, one could take content that you give them and make a totally new post, totally new video, totally new whatever, and not have to pay you for it because you gave them a license to it as part of the deal you already signed. And someone's going to test this one day, and hopefully it won't be allowed by the courts. But if it becomes a very standard practice in all the deals across the industry, that's a very, very scary proposition, in my view.
That's huge. Yeah, and I guess that's the trade-off that people have made by uploading content to TikTok. I would argue most people haven't really read the terms of service.
No.
But there's like too bad. You've accepted it.
Sorry, I could jump in. Do you remember that episode of South Park where they don't read the Apple's terms of service and I don't know, Stan or Carl gets roped into this horrible string of events that could happen because he just didn't read the terms of service. He just kept clicking accept. I'm reminded about that.
Yeah.
I mean let's be real. Who's read these terms of services, right? They're insane. Like, they're huge. Right.
I'm still on TikTok, but I've read them.
Well, you're a lawyer. I hope so.
Yeah. They're ridiculous, and they're made to be long on purpose in some ways to make it so that. But it's funny because there's some laws that make it so that you're not held to everything, but it's very gray, and you just hope that whatever it is that you're agreeing to isn't one of the things that will be enforced if it's extremely heinous. But it's just a scary place to be. And look, like the terms and service terms and conditions that you're agreeing to are problematic and concerning to me. But what I'm worried about is the smaller deals that are actually negotiated, because then you have no leg to stand on to say, how could I have been held to have read this over and over again? It's a much scarier proposition if that's the language in the 6-page agreement that you should have read versus like 40-page terms of service.
So that's the watch out, is any agreement that has similar terms like that. They can repurpose, reuse, train, and vague and broad usage, right?
Theoretically. And like for deals I've seen it come across my desk, I've had a pretty good track record of being able to get it taken out, or at least limited specifically to what you're giving them the access for, and saying like, it's specifically for this, you can use it for this and only for this. And that's worked pretty well so far.
I mean, the hot button one right now is Meta just walked back very quickly their AI, what was it, opt-out option for your content to be used to recreate yourself as an AI avatar or train their models, right? Like, I think you already signed up for train their models, but can you quickly tell us a bit about that one? Because that came out. Are you across that one? And
yeah, I know about it. I mean, I get all the news, and I laugh about it, and I am grateful that I'm not part of those deals, because I know that I would have been if I were still there. the minute I got the notification, the first thing I did was hop on Meta and immediately opt out. And I told my boyfriend to opt out. And I was like, this is going to be a big problem and they're going to get a lot of backlash. I wonder how long it will stay up, because there's no way. And it was funny because I said this as I'm like laying in bed at, 7 a.m, seeing that. I was like, there's no way that SAG-AFTRA is going to allow this to stand. And that's exactly what happened. They got so much backlash from the industry because what they're doing by allowing anybody to access your name, image, and likeness is they're devaluing your likeness. They're devaluing the value of creators' content. And also, I mean, what I thought to myself when I saw that is like, you're incentivizing people to make their content private, or not to trust you.
So essentially, the mechanism was that Meta brought out an option. Well, they were going to bring out an option where any user could create a deep fake of anyone else who was on Meta. So pick a name, creator, traditional celebrity, whatever. I could sit here and say, I want to make a deep fake of Ryan Reynolds and myself and Fred, and we're going on a surfing adventure. And unless he opted out of that, unless Fred opted out of that, I could go and do that, right? Like, and Ryan might want to come on a surfing adventure. Fred probably won't, but we could go do that in real life and make rad content. But like, that's not fair. Like, that's not great. But you can just imagine how far people can push this. But it doesn't really matter, right? It's using someone's name, image, likeness without their permission. They permitted that because they didn't opt out, but without their permission, and that's the sort of things you're trying to protect against. And
right,
yeah.
and there's a lot of, like you said, the ability for some random person. I mean, it would have been very scary for me, which is why the minute I saw it, I immediately opted out. I have a private profile for my friends and family, and then I have a public profile for the law firm that is content and educational stuff. Someone could have, in theory, taken a video that I made, me standing here talking about work for hire, and decided that they were going to say something super offensive using my face and my name. And I couldn't have really done much about it except for hopefully issue some kind of complaint and hope that the moderation engines are good. But I'm not a public figure in the same way that say a Mr. Beast would be or an Ariana Grande would be, and they also were opted in automatically into this. So someone could have done that with them. And they have more, under most state laws in the United States, they have more of a value attributed to their name, image, and likeness. So you could, I mean, this is what the law was made for, really, for name, image, and likeness in most of the states. But like, you could have Ariana Grande saying, go to this car dealership. I love buying cars from this dealership, and thereby endorsing something that she didn't actually agree to endorse. And that has economic value that she's not capturing. So that was a big problem. That's why a lot of these agencies and industry entities were really upset about it, is because of that part of it. But for the everyday person, it's also very concerning because someone who hates you can just do whatever they want with your face if you have a public profile. And that's absolutely terrifying.
With all this AI, sound like a Luddite, all this AI stuff moving so far, but like with the incredible speed of Gen AI and the capabilities, and like every week something more phenomenal and more powerful in replicating and recreating, how can a creator protect themselves then? Like, is there like just a general view that they can take?
It's really hard because the law doesn't catch up in time. Like in general, the law takes 10 to 20 years to catch up properly with whatever new technology there is. I mean, think about streaming. It took them, they were fast for streaming, honestly, but it took them like 5 years, maybe longer to get there. I know that there are laws that are currently being pushed through state and national, at the United States level, governmental legislative arms like the No Fakes Act, that aren't perfect but are something, and will give people the ability to stop things like deepfakes, and have to be asked specifically for approval on anything that uses AI specifically for them. The problem is we run into problems where someone can theoretically have said yes because there's some kind of mechanism where they have to opt in, or it automatically opts them in, or it obscures information about what exactly they're agreeing to. That's a big problem. And I don't really know how we solve that because we haven't figured it out for data. In most cases, the GDPR in the EU is the best, model I can think of, but it's really, really difficult for businesses. And so a lot of countries won't adopt that kind of law because it will create a stall on business in their country or in their economic zone. So it's a hard one because of how fast it's moving, because this is creating a new avenue for exploitation of intellectual property that we've never thought about before. I mean, all of the trademark, copyright, name, image, likeness rights law that we have is specifically about human creation. And so now, like, one funny thing that I love to talk about is like the same reason why AI generated contributions to a work aren't technically copyrightable is the same reason why a court ruled a long time ago that a monkey taking a selfie of itself wasn't copyrightable because it wasn't human. And so a non-human cannot own a copyright in something. So we're like having to relate things back to concrete human actions, and we're not there yet to really be. I mean, myself either. Like, I keep saying I'm becoming a curmudgeonly, like, old lawyer who doesn't know what I'm doing. I'm turning into that guy in the office who doesn't know how to print something, like, more and more every day. But like, that's where we're at. Like, all of the people who are making the laws are old. All of the people who are trying to figure out what's going on are too old to figure this out properly. And so I don't really know where we end up right now, but my best advice to every creator so far has been this: there's never been a time where having paperwork is more important. There has never been a time where having a trademark is more important. There are people like Matthew McConaughey and Taylor Swift and others who have started to trademark their catchphrases, trademark their appearance, trademark their voices, so that they can't get AI replicas made of them without monetizing it themselves. And there are ways to do that once you get to a certain point. Like, we have to get creative at this point and think about new ways to apply things that aren't really meant to protect something, to make it do that as best we can, and try to shoehorn as much as we can for the time being until there's laws that are very clear and tell us what to do for AI specifically.
Yeah, Rebecca, I was just, as you were talking, I was remembering back in law school and I went there a long time ago, and early days of the internet and apps, and the professors were like, we're genuinely worried about the speed the law can move at to catch up with the speed of technology. And that was then, and it is like 10 times faster. And I remember we're seeing showed us a video about this, a politician trying to explain how the internet worked, and he was likening it to like a series of pipes connected and racehorses working. And it was just so ludicrous, but you realize that even though it's crazy then, it's almost like that now. It's just not. A lot of people don't understand. They can't move fast enough to catch up with all the technology.
Yeah, that's absolutely true. And more every day, I'm like, I am that man who is likening an app to a bunch of pipes because I don't know what I'm talking about anymore when it comes to like how I understand, but I don't understand how they like even do it. And my sister's boyfriend is a neuroscientist who works with AI all the time. And so I will sit him down all the time because I need to know this stuff. I'm like, tell me how it works. And he's like, okay. But like, I'm in my 30s and I'm like still able to, get things and learn, and I care and I want to learn. But the people making the laws are like 80. And they had to learn how the internet worked, much less how an artificial intelligence is trained and how it works to create something different when it spits something back out at you. It's very difficult for me to like really wrap my head around all of the very intense programming that had to go into that. I can't even imagine being someone who grew up without a cell phone or an internet connection and having to wrap my head around that enough that I make something that affects other people.
I know Ant wants to ask a question about revenue and the revenue side of the business in a second, but one last question on AI is, previously when we were trying to make laws and we were dealing with technology moving very quickly. It was a very human-centric element. Like humans program machines that did these things, and now machines are programming themselves and learning themselves. And sometimes you'll ask, people who program these machines, like, how does this working? And even they will like, I don't know. It's doing its own thing in the background. How do you make laws that keep up with that?
It's a great question. I've been asking the same thing. I'm blessed to have my boyfriend's a software engineer, and so I will sit next to him and watch him do stuff because I'm trying to understand it better myself. And just like you said, AI is programming itself. AI is programming all kinds of things, and software engineers are looking over and making sure that the code is correct, but they don't always know exactly how it's doing what it's doing. And he does, but there are lots of people working on different kinds of layers that go on and fold in on themselves. He's an app engineer, so it's a little more like one thing goes into the next and he can see it. But I know that there are other layers that exist. I couldn't even tell you how we even begin to try to regulate that until we understand as like a population what's going on, which we don't. And the problem too is like the people who are making the laws are not themselves programmers, often don't have access to them, and don't speak even the same language as the programmers, because it's like such a technologically very specific, very term of arts heavy language that like the lawyers who have to come up with all of this stuff are like, my head hurts, I don't know what to do. And I've seen that a little. I don't, obviously I'm not involved with legislation about all of these topics, but like I've seen that inside of companies where they're like, I don't even know what to do about drafting these contracts to, that you have to think so hard and so far in advance at this stage of like, what is every possible use I could possibly need to cover off on as an in-house lawyer to make sure that that's covered if I'm licensing in, and if you're on the rights holder side and you're licensing out, what is every possible use that the other person could use to get around the parameters that I'm setting to try to make very clear what you can use. Like it's this very weird dance that it's always been there, but it's so much more complex than it ever has been.
I want to stay on this AI side street because there's like a lot of, unknown in the platforms or tools or products using name and likeness and how do creators protect that. But a lot of creators are actually using Gen AI to create content. And you mentioned before that like the chimpanzee or the monkey taking a selfie can't own the copyright. The machine making the content can't own the copyright. What's the implication then for a creator using Gen AI to not wholly create content, but to help make content, whether facilitate or be a tool that they use in their content creation? Are they exposed in any way?
Sometimes. So if you use it for non-copyrightable things, like if you're speaking from a music perspective, mixing and mastering isn't really copyrightable. Just to set the stage, copyright applies to an original, independent, creative work that's fixed in a tangible form. So that could be a live stream or a recording. It's a CD, it's a vinyl, whatever. And well, the live stream, by the way, would have to be recorded somewhere, but usually they are, which is why I say that.
How about I'll throw a few things at you, like if I use Gen AI to write a script.
Yeah.
Is that mine? Can I protect that? Or is it copyright?
Did it write, how much of the script did it write? Did you just prompt it and say, write me a script?
Yeah.
And here's like a general concept?
Yeah. Let's say I prompted it.
You own nothing.
Okay. What if
you own the prompt that you wrote?
What if I then write a really rough structure and show it some of my old videos and then it punches out a script?
There's a little gray, but like you probably don't, because concepts, which is what you're basically giving it, those aren't copyrightable. Ideas aren't copyrightable. It's the actual creative expression that is. Okay. So ultimately the creative expression is coming from the AI.
All right. Thumbnail? Like if I use an AI thumbnail generator?
Well, so here's the thing too. Do you really need, for a script, you do need the copyright
Uh-huh.
for most of because you don't want somebody else to go and make the exact same thing. Do you
Yeah.
really care about the thumbnail all that much?
Don't know.
That's the other thing. So like you don't have to have like if the AI makes it, no one owns the copyright. So you got to keep that in mind too. Like it's not like someone's going to come and tell you you're infringing because nobody owns it.
What about
It just means you can't tell somebody else not to, right?
yeah. What about like character design and logos and things like that? Like it's pretty powerful stuff. I think I know the answer, but
the copyright wouldn't be you, but you can use the trademark because you don't have to have created it. You just have to be using it in commerce.
okay. Nice. Good to know. What if I use my voice, but it's like AI is being trained to then spit out like an AI version of my voice and read scripts?
Voice isn't copyrightable anyway.
Okay.
So that would be covered under name, image, likeness, kind of. This is a big thing. This is like a new frontier, right? Yeah. There wasn't a time before where someone could completely mimic your voice to like rewrite something without it being somebody else's voice. So this is something that's like really tripping people up legally because we didn't contemplate this. Like this is going back to we did everything based on human creation. So voice is going to be hard because there's nothing that really protects it in the first place. And the best, like trademark might, but we don't really know yet. And name, image, likeness might, but in the US, like it's state by state. Some states have good protections. Some states don't have any protections really at all. And it's like really, really complicated in the Wild West to figure out like who has what protections at this stage. If you wrote the script and you have the AI mimic your voice to say the script, then you own the script. And we don't know what's going on with the voice thing, but like in theory, you own your voice. Unclear how at this stage. And if you gave the AI, if you spoke into the thing and the AI's terms of service say they can use your voice or anything you give them, then they can use it. And they don't own the copyright, but they can use it.
It's a fun game. Fred, you got one? This is a fun game. Like it's scary.
No, I'm just, my head is reeling from possibility to things that can happen now. But it illustrates what you were saying before, Rebecca. It's like, it's a new age and there are so many scenarios, and every time something new comes up, we don't necessarily have a legal response for it yet.
Yeah, there's a lot of room right now for test cases where someone will just sue somebody else to make a point and figure out where the law stands. And it's a scary time to be creating new content, but also a very interesting one.
Yeah, and look, we're getting short on time, and I really do want to cover the revenue side of things and a part in the business. We've talked obviously about the IP, the content. Creators obviously, they want to be sustainable. They've got to make money. How do they do that? What are the best sources? What protection do they need there? In your opinion, out of all the revenue options that creators have, which are the easiest from a legal perspective? Which are the most complicated from a legal perspective?
So everything's complex in its own way, but merch, where it's like you're making like a t-shirt or like a mug or whatever, licensing out your IP in like YouTube form and making money off of that from ad revenue, digital products, they're all that same IP structure we were talking about. And it can get dicey, but we kind of know, well, unless you're using AI, we kind of know where you stand. And they're complex. There's a lot going on. You still need someone who knows what they're talking about, or you can get into a really bad place. But something that a lot of creators have been doing, that it's a great business opportunity and it's really cool and I like it and I'm super here for it. But it creates a whole new level of complexity because they already they're going to have that IP business, but then you're adding another layer is where they start creating consumer goods. So like think like Joyride, Feastables, Alani Nu, like all of them, they have to think about those like run-of-the-mill legal and business issues that come with your standard creator business because they're still making content. They're still doing all of the creator stuff. But then they also have to think about, because these three are food products, right? Just off the top of my head, like you've got compliance with regulation, food safety, allergen disclosures, nutrition disclosures for certain states. They have to think about the agreements that they have with a co-packer because they have like the co-packer is like the manufacturer that's going to make things to their specifications, having like clear agreements with the co-packer about the formula and their processes and whatever, making sure that they own that IP and that the co-packer has no right to say, oh, well, we kind of co-own it. All of those things just add a whole other layer to what you're doing. And it can be a big problem. And it's legal exposure and it's also reputational exposure. Like Chef Peely's Pink Sauce had like a huge scandal where there was like inconsistent coloring. There wasn't in refrigeration instructions. It wasn't clear what their there wasn't transparency about ingredients. And that made a big splash. It was a big scandal and it made headlines and it was really bad for them. Whereas like Mr. Beast's Feast of Bowls is like a huge seller. Joyride's a huge seller in Target and other big retailers, and is just like a huge moneymaker for these companies, for like the creators' overall holding company. And Alani Nu is like, gosh, like I don't know anybody who doesn't drink it. So it's like a really great opportunity. It's also such a whole, you're like entering into you're then becoming a holding company that has several different business streams, and it's very complex.
And you'd also be working across a lot of brand deals specifically that creators are individually, I guess, negotiating, and they'd probably be at different scales, as you know, from the small one to the biggest ones. Is there a really common issue you typically see creators sort of have, or a mistake they typically make in those deals, especially around like the revenue they end up getting at the end?
Brand deals?
Yeah.
I mean, it's not even about the revenue they end up getting at the end, because a lot of the time brand deals tend to be kind of flat fee, unless they're doing something that's an affiliate structure, which sometimes is worth it. But I'm not the biggest proponent of that unless you're really, really sure about the numbers being worthwhile to you. Because the problem is like with affiliate or with per view or per click marketing and revenue associated with that, you don't have a whole lot of control over that. And so you can put in a lot of work for very little revenue, and it ends up falling a lot on the brand's inability to push it out. So there is that, but it's the breadth of the usage and the devaluation that comes with that is really a big thing. And, you know, I like make the like very like exaggerated example of like, you could sign a brand deal for $200 and end up on a billboard on Times Square and get paid nothing for it. And that's a huge mistake people make. It's not that people are getting that done to them all that frequently, otherwise we'd hear about it all the time, but like the reality of what a brand can do with what you're giving them if you're not being careful is very real. And it's not that people are getting paid nothing, it's that people aren't getting paid the value of the work and the value of the actual IP that they are licensing out.
How do you know that? How do you know what that value really is as a creator?
It can be hard. There's a book that I read called Sponsor Magnet that has a really good structure in there, and I recommend it to a lot of folks.
That's from Justin Moore.
Yes.
Yeah. Shout out.
Yeah. Excellent.
Friend of the pod.
Oh, wonderful.
Yeah.
Very, very good book. I really like how he thinks about his pricing strategy, and I recommend it to anybody who's looking at how do I even price out what I'm doing. My friends who are creators use that as their strategy as well. And then, you know, you kind of feel it out based on what you're getting. You have, what is the overall field of what you're getting at? And this is also why you want to have a team of people who are really experienced in the industry, because they will have a broader experience in what those brand deals like are looking like right now, what the campaigns are looking like, how much they're paying, what to charge, all of that. The other thing that I saw a lot of as an in-house lawyer is you may think that you know why you're getting offered a certain amount, but it might not be that clear. Like certain campaigns will have different tiers of different creators, not based on follower count or engagement straight, like directly. That's definitely part of it. But sometimes it's like, is the niche like straight on what we're looking for? How much do other creators look up to this person? And will that get us in their heads? That's something that's very important that a lot of people aren't looking at as an individual creator and don't think about. So like if you're getting offered a deal that's like very in your niche and most of your content is about that particular niche, most of your followers are very involved in that niche, you are what someone would say is like an influencer to influencers in that niche, then you should be asking for more money than if it's like kind of a side thing that's like maybe a little ancillary to what your overall online brand is, online presence is, but you might still have an interest in someone still offering you a deal. You will probably see very different offers for those two different things, even with the same following.
All right, we've covered some serious ground, and it's a lot of it kind of feels a little bit complex, right? So I want to get the complexity simplified a little bit.
Sure.
And so if we've got, creators tuning in, they're generating good money, they're building a business, but they're sort of really operating like a solo creator. Let's be honest with them. What's like the first legal move or moves they should make right now to start protecting their business now?
The first thing to do, like I mentioned it before, is like a big thing that I think is really important. Get your entity situated. Don't wait until somebody tries to sue you or go after you or you take out a loan to do that. It's better just to get it done outright. It's going to cost you, in California, it's going to cost you $800 to set up an LLC in taxes, and then it's like another $100 to file it. It's worth the money and then some. That's number one. Number two is like talk to a lawyer and know who you would call if you had a big brand deal and you needed something turned around right away. You don't need to immediately engage with them, but having an idea of who you would go to and have on your team is important. And like something that's a little controversial that I recommend to a lot of people at the beginning of their careers, especially, is like, I know there's a lot of management companies and a lot of agents out there who will get you brand deals and do all of that. Most earlier stage creators need a lawyer and an assistant. They don't need to pay somebody 15, 20% of their earnings necessarily at the very beginning. After you start getting to a place where you need outreach, you need help with like all of the business logistics aspects, that's when you start bringing in somebody. But if you can't afford, to pay them the 20% and you need that money, like that's the beginning. You can just like have somebody on an hourly basis take inbound for you if you need it, and then have someone review your agreements and make sure that they're clear. That's another thing, is like make sure you have those people on your team, like the very early stages people on your team, and then just make sure everything's documented and you have it written down as best as you can and keep it in a safe place. Don't lose it. Don't put it on like your computer without backing it up, because you will be so sad years from now if you're trying to license something out and you need to show that you have clear IP, and then you can't do it because you can't show it. Like I had it when I was a very, very early lawyer, like a baby lawyer. I was helping to sell a TV show, and for the production company, like they were selling episodes, and they had the most insanely disorganized, because it was like back from like, it was like 30 years plus of this show, and they had no chain of title for anything. And the amount of money, I mean, let's remember this was like a big fancy law firm that was like billing out their first year associate for hundreds and hundreds and hundreds of dollars. Like a like mid-level associate was upward of $1,000 an hour to do this and go back and reconstruct everything. Like you don't want to be in that position. And it's so easy to just do the quick, just like, write everything down, make sure it's saved somewhere now, than to later be going back through and looking at all of that. So those are first three things I would do. Get an LLC or a corporation if you really want to, and you're sure you're going to get investors. That's what the corporation would be, because there's shares, and a lot of like VCs won't invest in an LLC, and you'll have to convert it later, which is a pain. But LLC at least is good. Getting a really good, solid, like beginning team of people around you. You don't have to bring them on full time or anything, but like having people who you trust around you who can help you out. And then also just making sure everything's in writing. Those are like first three clear, important things you've got to do if you want to take this very seriously. If this is just like a fun hobby, that's a different story. Like you don't worry so much about the IP, but if it's like you're taking this seriously, which you should, because there's a lot of money in it, those are things you should do.
I love that. And to riff off your last point of documenting everything and keeping a safe place, there's a creator, Shannon Jones from Bounce Patrol, an amazing channel. I've lost count of how many, probably 35 million plus subs, billions and billions of views, and every year they update their. I think we've called it that, and maybe the Doomsday Book or
Doomsday Checklist.
Doomsday Checklist, and they document if this happens, who do I call or what do I do, and it's written down. So my channel gets deleted. Who's my contact at YouTube, and if someone tries to dox me, who do I call? Here's my lawyer if something happens. So a very simple doomsday checklist that gets updated and then gets saved online and off. It's a beautiful thing. Rebecca, thanks so much for joining us on Creator Generation. I am equally scared and excited for the future of creators protecting their businesses. Yeah, you and I both. Thank you for having me. Creator Generation, look on the mic.